issues and not doing just consultative visits. So we're very grateful to have Lisa Prince and Lisa Yoki here with us today to help us with this important issue. The Prince firm represents employers ranging from Fortune 500 companies with thousands of employers in many states to local small businesses of every size. The firm focuses on all aspects of the California Occupational Safety and Health Administration, including advocacy during rulemaking, compliance assistance, management of enforcement activity, and appeal of citations. Lisa Prince is the principal at the Prince firm, and she has represented employers on OSHA and Cal-OSHA matters for over 17 years. Lisa has worked to ensure that her clients' defenses are investigated thoroughly and efficiently, evidenced and carefully discovered, preserved, and presented, and that thorough, zealous advocacy, her clients receive fair treatment at the hands of sometimes imperfect regulatory system. Also, Lisa literally co-wrote the workplace safety guide that is used to train other attorneys in advising their clients on Cal-OSHA issues. And then Lisa Bioki is the senior associate at the Prince Law Firm, Santa Rosa, California law firm that concentrates its practices on Cal-OSHA and Fed-OSHA along with crisis management. Lisa represents the firm's clients in all aspects of Cal-OSHA and Fed-OSHA administration process in defense, as well as amicus curiae and appellate briefs. She also assisted employers with crisis response, improving and understanding their safety programs, as well as managing pre and post appeal abatement issues before Cal-OSHA. And before we dive in and I turn it over to wonderful team, we just want to make sure that you're aware that the information that is presented today is as of today. We know new information is coming out at an unprecedented speed. So continue to check the appropriate COVID resources for the most current information. And of course, should you have any questions during the presentation, please feel free to ask. We'll have the chat feature going and we will help navigate those questions for both Lisas and make sure that we give it proper attention this afternoon. So without further ado, I am going to turn it over to Lisa Prince and Lisa Bioki.
Lisa, you need to unmute yourself. Here we go. Better? Yes. Okay. And you can see the PowerPoint at this point. Yes. All right. I'm going to start that. So as Emily indicated, I guess I first need to give you our disclaimer. And this subject, always, Cal-OSHA is changing all of the time. In this subject, more than others. As we all know at this point, we're a few months into this, and recommendations and guidance are changing all of the time from various different sources, and it is, pretty difficult at times to keep up with that. I know we are recording today, and it's fine that we want to come back and reference this presentation as necessary, but I do really want to reiterate the point that this is a point in time, and we have gathered this information to the best that we can to be current right now, but that might change pretty shortly, and we're going to talk about upcoming things at the end of the presentation. But our focus right now and at the start will be what Cal OSHA and what the division is doing right now to enforce the COVID-19 hazard in the workplace. So that will be our focus. And at the end of here, we are giving general advice. We do want to answer your questions as we go along. And if you do have any questions, please do let us know. We're happy to do that. Probably if you have a question that is very specific to your situation, we can, discuss that after. We want to keep this fairly general and to be relevant to everybody in the group. And just also, this is not a privileged conversation. We can't give specific advice. We could do that in a different context, but right now we want to keep it general for everyone. So Lisa Bianchi is going to talk about some regulations we currently have in place that the division may look to as they are doing their COVID inspection.
All right, so just, shoot me a note if you guys can't hear me. So right now, there are no current Title VIII regulations that directly govern COVID-19. Now that being said, there's an emergency standard that they're working on, and Lisa will talk about that a little bit later. In the meantime, the only way for the division to enforce any COVID-related violations would be through the existing regulations that we have under Title VIII. And keep in mind that Cal OSHA only enforces Title VIII regulations. So there's a lot of other information and requirements out there through the health department and the state regulations and that type of thing. So keep in mind, Cal OSHA in our conversation here is generally limited to Title VIII. So, and I'm sure you're all, up to date somewhat on the Cal OSHA website. They provide a tremendous amount of guidance by industry and also just generalized. So if you haven't been to their website, I highly recommend it. There's a lot of information there. It will, as Lisa mentioned, be changing constantly. One of the things that's been mentioned to us is that when those are updated, when the guidance is updated, it's not always, you're not informed. You don't know when it's going to be updated, and you may not have a copy of the previous version. So it would be recommended to keep track of the previous version in the event that you ended up with a Cal OSHA inspection and a citation. You want to know what guidance was in place at the time and not what's in place several months from now when you get citations. So that's a big task, but just know that it is changing, and the old versions are not always left up or obvious, and the changes that are provided are not always obvious. So just a caution there. The current regulations that we have in place through Title VIII that the division may be looking to, they vary. So for instance, as we have listed here, section 5199. So that's the ATD standard, typically specific to hospitals, medical offices, healthcare industries. So for you folks, probably not the most relevant. However, when you look at the PPE requirements, that is something that should definitely be coming into play for you. So for instance, section 3380, that does include respiratory protection. If you look at it at subsection D, employers are required to do a hazard assessment of their workplace to determine if there are hazards that would necessitate PPE. So if you do that assessment and determine that you have employees that may be exposed to COVID, should COVID come into your workplace, you need to have a plan in place for that, proper PPE, and then you need to be training employees not only on the awareness of that potential hazard, but also on the PPE that's required. That's something that often gets overlooked. You just hand out a mask and people aren't wearing it properly. Make sure that you're training folks. Sections 3382 and 3384 are for eye protection and hand protection. Arguably less applicable, but I wouldn't put it past the division to find a way to issue a citation under those. So just take a look at what your workplace is and assess it and determine whether either of those would be appropriate. Sections 3362 and 3366. 3362 is the general sanitation requirement. That will refer you, has internal references to 5140, which is the control of hazardous substances. So if that's applicable to you, pay attention to that. 3366 is washing facilities. Now, as far as ag goes, I'm sure you're all quite aware, you have your own regulation for field sanitation. So just be paying attention to that and make sure that you are complying with that particular standard. And know that it's something the division may be looking at. Lisa, do you mind going to the next slide? Thanks. So more existing regulations. 5141, control of harmful substances. This has requirements for engineering and administrative controls, but also respiratory protection equipment. And then it will refer you to 5144, which is the respiratory protection plan or standard. That is a lengthy and complex standard. I know that when we have cases that involve respiratory protection, we will often rely on an expert to parse out that regulation. So if you're looking at that standard and you're not sure, I would recommend getting a professional, safety professional involved to assist you in reading through that regulation and making sure that you are properly adhering to all of the requirements there. Section 3042, that's the reporting requirement. So as you're probably aware, you are required to report serious injury or illness within 8 hours of your knowledge of that serious illness. Note that first responders do not report for you. This is something we see come up, and I'll just throw it out there so you're all aware. Just because the first responder is calling it in doesn't mean you don't have to. And this is getting a little bit difficult, I would think, in this environment, because if someone becomes ill, it may not be obvious that it's COVID. It may take a while for you to figure that out, but once you are aware of that, and if it is at all work-related or could have possibly been contracted at work, there may be a requirement there to report. So keep that in mind, keep a paper trail of your investigation and the information that you've collected, so that should it come to a situation where you have a citation for a late report or a failure to report, you can demonstrate your due diligence down the road. Section 14300.4, that's the recording criteria for illnesses. So think log 300, that type of thing. And note, and we'll talk about it a little bit later, there's a new assembly bill that went through that refers to the log 300 requirements and the information there when reporting COVID illnesses. Lastly, in this section, we've got 5193, that's the bloodborne pathogens. There are references in this regulation to PPE because it also makes reference to other potentially infectious materials. It's worth paying attention to. It's typically more addressed under healthcare, but it's something to keep in mind just because the division doesn't have a specific COVID requirement, and honestly, they'll probably look for whatever they can in order to cite employers should there be a COVID illness. And I believe, Lisa, it's on to you.
Right. So any questions regarding the regulations that we've discussed so far? Go ahead and enter those in the chat box, and we will address them, as we come up with everyone's help. But I want to talk about what's going on and has been going on the ground. So when Cal OSHA, or the division, the enforcement branch of Cal OSHA, they are in charge of conducting the inspections and issuing citations. So there was a little bit of a transition on this. So over the summer, we saw a lot of compliance assistance, which, I believe was a great idea. When a Cal OSHA inspector visits a site, they can do that with the focus on helping that employer come into compliance and addressing the hazards, and then they can move on to the next employer. If they're doing it, kind of in an enforcement role, they're definitely probably going to spend a much more time on the paperwork side and addressing, issuing the citations, developing a file on that. So they were able to reach a lot of employers during the first month or so of their efforts, and a lot of education. So that was a great idea. I don't, fault that for a moment. At some point, there was a shift on that. So we shifted from the inspectors out providing compliance assistance to out enforcing their guidance. And that's what we'll talk about a little bit further. So in speaking with the inspectors and speaking with district managers, definitely saw that change and encouragement to get out there. And some inspectors were very much out there enforcing. They had their own issues to deal with as well as inspectors, and making sure that they weren't exposed to any hazards. So there was different policies probably in place. We're not sure exactly what the overall policy at this point. It does appear to be a little bit different with all the offices and maybe even with the different inspectors. But we are now starting to see the citations. We're starting to see where the division is focusing and how they're enforcing the regulations. We will talk about a petition that would give us an emergency COVID regulation that is not in effect yet. So the division is focusing on the regulations that we discussed, as well as the IIPP, which we're going to give a little more time to as well. So as Lisa indicated, there is published guidance. And again, I do caution you, look at that routinely. It is general guidance as well as industry specific guidance. There is definite, specific guidance focused on the agricultural community. And an example, I just wanted to point this one out. So we have a document on the website that was put up in July of 2020. So it's the Safety and Health Guidance Document for COVID-19 Infection Prevention in Agriculture. That document was updated just on October 27th. So checking that periodically is important. There was a change to that in that there was updated criteria for when return to work after a diagnosis, with a reference to California Department of Public Health guidance on that issue. So that was updated. One thing I also noted is, and as Lisa indicated, it is a burden to go, not only to go and see what has been updated, but figure out what the change was. And this is a numerous page document. It was one change, trying to find, what is the significant difference. So what they've added in the back of this document is a guidance revision and update. And so, starting there to see what has changed, and it looks like they're now starting to try to keep maybe a better record of when this information was put out and how it's being changed. So we do want to watch for that. Is that to be helpful to us? I don't think so. In speaking, it's fine, it is helpful to us, but in speaking with, managers within Cal OSHA, they did express a concern to me that in their enforcement of the regulations based upon this guidance, or I should say enforcement of the guidance, how were they going to make a case 6 months from now if they couldn't show that this guidance had been published, at the time of their inspection? So they have, changed that. The other note I would make on this is I'm hearing pretty consistently that if an employer is issued a violation that has anything to do with COVID-19, it will automatically be classified as serious. I see a little tiny bit of deviation from that in the practice, but really not too much. A significant number of serious citations being issued. So the OSHA started issuing citations. I have reviewed the citations issued under COVID. So those began on August 25th. Those were the first citations we saw under COVID. Now this slide here really is the enforcement report. So according to OSHA, their focus at this point is on enforcement of 3203, which is our IIPP regulation, and then also the respiratory protection. So we're not seeing too much of the other regulations that Lisa mentioned. However, there is some of that as well when we look at what's actually going on. OSHA leadership has said they are focusing on response to complaints and then outbreaks at clusters that they receive information from health departments and otherwise. So the cases. So I have reviewed all of the cases, and I want to talk to them kind of in two different groups. And before we do that, we do have a question, and it's a good one. So what do you mean by IIPP that is not enforceable? I may have misspoke. We're going to talk in detail about how the IIPP regulation is used to issue citations on this subject matter. So we're going to talk about that in detail. What's not necessarily enforceable is guidance documents. Guidance documents are not regulations, and they cannot in themselves be the basis for a violation. However, and I'll say this briefly and we'll talk about it in more detail. Well, let me do it in context of this. So in the cases, here's where we're seeing violations. Very much, I would say 90–95% of these violations are alleged violations of the IIPP standard, the IIPP 3203. So there would be, to give you an example. So first, I looked at some kind of the big ticket cases. There were a couple non-ag employers who seemed to get pretty hit hard on this. So they each received, I think, 7 serious citations. The penalty packages are up to and over $100,000. But of those serious citations, we had one for the PPE analysis that Lisa mentioned earlier, but all of the rest were under the IIPP regulation. So there was serious citations issued for one, not communicating with employees on the topic of COVID-19, 2, not enforcing social distancing, 3, not conducting investigations specific to COVID diagnosis. For whatever reason, there was a repeat on the distancing issue, and then the last one was for failure to train. So each of those were issued as serious citations. Specifically, with review of employers in the ag industry, I also saw a main focus on citing the IIPP regulation in a couple different ways. One was for not providing shade to the extent that everyone using that shade could be properly social distanced. So in some cases, we see that as one citation under IIPP with a reference to heat. So that was in several cases. In another case, it was actually resulted in 2 citations for that issue. So again, not social distancing and not providing enough shade. Other serious citations included not enforcement of face covering, not evaluating the hazards associated with COVID-19, and not providing distancing or barriers, and then another one for not training. So really all of those citations are issued under 3203. So that's where we are at this point. Very much focus on that, but where it may have been confusing earlier, it's the vehicle for the citation is 3203. The specific factual allegations are being taken from the guidance documents, if that makes sense, I hope. But please do let us know if you have any questions regarding this as we go. I'm going to go to our next slide. And that's the one, IIPP and COVID. Lisa.
All right, thanks. So as Lisa mentioned, predominantly citations are being issued under the IIPP, and but as you can see, the references are to some of the guidance, you know, for instance, social distancing, barriers, that kind of thing. None of that's in the IIPP regulation, but that is how the division is working its way around that and in finding a way to issue for COVID violations, so to speak. So when it comes to the IIPP, I'm sure you all know what that is, Injury and Illness Prevention Plan, the requirements at 3203, and as a California employer, you're required to have a plan. You have to have one in place. Generally, our recommendation is to keep that, you know, what we call lean and mean. It does not and should not be a 50-page document. It should really just have the requirements that are there at 3203. Anything else you have, this is kind of COVID related, but also not, and just our kind of general suggestion is keeping your programs all separate. So for instance, if you do have a COVID plan, keeping it separate. If you have a ladder safety or respiratory protection plan or any other specific safety plan, keeping that as a separate plan from your IIPP. They can all be in the same binder, but keep it out of your IIPP. And the reason for that is whatever is in your IIPP is enforceable by the division. So even if you were to put something in there that's not actually required under 3203, for instance, your COVID plan, they can enforce that COVID plan even if it's not in their regulations. And that's because it becomes part of your IIPP, and as an employer, you're required to enforce that. So it's hard because it discourages folks from maybe going above and beyond, but you don't want to get caught not enforcing your IIPP and end up with a citation if you can help it. So as Lisa mentioned, there is an emergency regulation in the making. I think I've mentioned that as well, and we will discuss that. But in the meantime, the IIPP is where it's at. So you're required under that regulation to evaluate and identify workplace hazards. So that's where they're really going to look. So under what circumstances? Obviously when you have a new program, but also when there are new procedures introduced or when you're made aware of a new or unrecognized hazard. So arguably, COVID really falls under that category. It's a new hazard that has been introduced into our workplaces, or at least a potential hazard, and it should be addressed. So what are your procedures that you're putting in place as a result? So those are all things that are covered under the IIPP regulation. Once you have done an evaluation and figured out the potential hazard of COVID and where that might be introduced into your workplace, then you need to have procedures for correcting or preventing that particular hazard. So that is where putting a COVID plan in place, I think, is actually a good idea. There are a number of safety professionals out there who are putting together good plans, and I think it's reasonable to have a plan in place. Just don't make it part of your IIPP. Once you've put that plan in place, you need to communicate that to your employees. So they need to be aware of, you know, what it is that you're doing in order to minimize this potential hazard. And then you also need to be training them. So I mentioned before, you know, if you have a respiratory protection plan or you're requiring PPE of any kind, not only do you need to inform your employees and your supervisors of that, but you need to train them. You need to train them on those proper procedures for using and keeping, maintaining and cleaning the PPE as it is necessary. Where can they get new PPE if they need it? All of that is something you need to be keeping in mind and training your employees on. But also keeping a really good paper trail of what you've done to put that in place. So if you're doing training for your employees, make sure you're documenting that training. And that goes for your hazard evaluation. Make sure you documented that you did that. Because when the division comes along and wants to know if you've addressed any potential hazards and you have documents to demonstrate that, at least makes it more defensible should they issue a citation. Doesn't mean they won't issue one, but it does make it more defensible. You do want to have procedures for investigating any potential COVID cases that may arise. So and I'll address this a little bit later when we talk about AB 685, but you want to have, as part of your COVID plan, procedures for when there is potential exposure. Once you become aware of that, you need to have a plan in place for how you're going to address that, and then meet all the requirements that you will be required to meet once AB 685 comes into place. So you want to train your supervisors and management so that they all know exactly what they're supposed to do in response, and you want to have a plan for what you need to do for your employees to make sure they know how to respond as well. And again, all of this ends up coming back to your IAPP, which is this, one program, but clearly the division has found multiple ways of citing employers in one investigation under this particular document. So, and I'm sorry, I'm just gonna read this question that came up real quick so I don't let it get past me. The question is, if employees work more than 6 feet apart and the hazard has been addressed, employers still required to have employees wear a face mask. After reviewing the California requirement, we have employees who wouldn't need to wear a face mask, but I keep hearing regardless, the Cal will cite you. That's a really good question. And I actually had someone ask me that just the other day. And I will say the guidance it's not actually 100% clear. It does seem like if you have employees distanced enough, even if you're inside, but if they're at what is considered a proper distance, that perhaps face coverings aren't required. That being said, I wouldn't put it past Cal OSHA to cite you regardless of that. But I think part of the problem becomes as people move about. Certainly if you have common areas where people are going to be interacting, stairwells, hallways, elevators, when they're waiting for the restroom, that type of thing, certainly they should be wearing face coverings. But what happens when somebody approaches someone else's desk or they happen to move through a space that isn't a common area but is someone else's area? So there's a lot of places where that can become kind of a slippery slope. I know personally, I struggle to remember how far away 6 feet is. My son is 6 feet tall, and I try to envision him laying on the ground. But it's a big distance. It's farther than you think it is. And so I think a lot of folks think they're 6 feet apart and just don't realize it. And that's not their fault. It's a measurement we're not accustomed to recognizing. But I think that, when you're dealing with folks that are more than 6 feet apart, if they're very safely 6 feet apart, especially if they're working individually somewhere, I could see where having the face covering wouldn't be required. But I think anytime you're going to be getting close to that, it's probably better to have them wearing a mask than not, because I suspect the division would find a way to issue a citation, just honestly. So hopefully that answers your question. Feel free to throw another one out there if I didn't. So I think I've covered this slide, Lisa. I believe it's on to you.
All right. Before I go next slide is what's coming next. I didn't specifically mention this, but in light of that question, very relevant. In this one of the citation packages I did review for this, I'll just read part of it, and I think this will help us do that analysis. This is really more focused on social distancing, but this serious citation is based upon, and it lists these specifically, a lack of social distancing at carts where employees put on gloves, where they're clocking in the lunchroom, and where they store their coats. So I think the example of what Lisa was mentioning is that we may have focused on our work area and said they're 6 feet apart. We don't need to, we're social distance for one, or we don't need to do the face covering. But an analysis of everywhere that employee is going to go related to completing their work, and then, ancillary to that, getting their equipment, using the restroom, going to the break room, that probably, based upon what I'm seeing on this citation, should be part of that analysis. And I agree with Lisa, analysis is the key. In speaking with the inspectors, for instance, one said, well, if everybody's 6 feet apart working outside, I'm fine with that, but he said it really is going to depend on if we're maintaining that and enforcing that distance. And then he made it clear to me, I'm not speaking for the division. This is how I would look at it. So there are still a lot of unknowns with this, because we have some guidance, and we have this, IIPP regulation that does seem to address this issue. I mean, it really does, and it can, but there are still a lot of unknowns about what the expectation is out there. Okay, and I think, if there are any other questions, do let us know, because we're going to kind of switch gears and talk about what is coming next. Because I indicated we do not now have a regulation that is specific to COVID-19. We have one in healthcare. We have aerosolized transmissible disease, regulation that's been in place for quite some time, but that is specific to healthcare. So we are talking about in general industry. So a petition has been submitted to the OSHA Standards Board, proposing that one, we need to get an emergency standard in place, and two, there also needs to be work on a permanent standard that would address this situation. We might, have other similar situations going forward. So the Standards Board has reviewed that. They did obtain reports from actually their own staff, as well as the division staff, regarding the need for such a regulation, and have fairly recently ordered that they in part approve that the petition, in that they've sent the issue to the division, who is in charge of drafting health orders, and ordered them to submit a proposal by November 19th. So we are looking for that. There will be a meeting on or about November 19th, wherein we expect to have some proposal on the table. The division has also been ordered to work with Standards Board staff and start an advisory committee to review and recommend amendments to the emergency standard, as well as ultimately a permanent regulation. So that is in the works. Do we know exactly what that's going to look like? No, we don't, but we can talk a little bit about what the petition was. So what would that proposal require? And it is, fairly extensive. First, it would require a written action plan specific to this situation, COVID now, but probably we're going to be talking about aerosolized diseases generally. It would require procedures for identification and evaluation of the hazards, procedures for control of the hazards. Now, so far, we're really talking IIPP issues, aren't we? So very similar, but that will be in a specific regulation. The proposal also talks about what the employer's obligation will be when you have a situation. So when you have a situation of an employee being diagnosed, what to do. What are you going to do, when that happens in your workplace? You will be sending that employee home. You will, what they're saying in this proposal is have policies in place to not discourage the employee from staying at home, so it wouldn't be to their detriment to stay at home. and we're notifying other people. We're sanitizing workplaces or things like this. We're also going to have procedures in place for when we have an employee with symptoms. How are we going to handle that? Very similar issues. And then also when an employee reports an exposure. In that proposal also would be required a job hazard analysis. Again, really talking about what we're already talking about under IIPP, where you would look at each specific job category. So each kind of general work that you have, look at it in respect to what social distancing protocols should be in place, ventilation issues, hygiene, personal hygiene, as well as the maintenance of the workplace for sanitation, what personal protective equipment would be required, face coverings, respirators, etc. And then specific training for each of your work categories, and then records of how you're maintaining that. So I would imagine, that's going to be training records like we have now. We are required to provide training in a way that would be understood by employees, and then document that training. And also documenting our inspections to make sure that we are following these procedures and policies and enforcing them as well. So will be record responsibilities under this proposal. Also talking about reporting these situations to employee illnesses, employee diagnosis, reporting that to Cal OSHA, as well as county or other jurisdictions, health department. So that is different. We mentioned reporting that is currently in place. So currently we do have a rule that if an employee experiences an injury or illness at work and is hospitalized in this situation, the hospitalization would be key here, that would be reported to Cal OSHA. Also, it was reportable, and if an employee experiences a serious injury or an illness that was work-related. So that's when Lisa mentioned we're doing that analysis. We will continue to do that under the current regulation, but under the proposal, we will be talking about actually a separate call within one day to Cal OSHA if we have an employee, diagnosis. That we're not sure what that's going to look like on November 19th. But that's something, all of you, we should be watching. I want to just actually mention AgSafe has a wonderful resource on their website. I did review that this week and have before that does, good resource for all of you to keep up to date. You may also, just be checking the Cal OSHA, the DIR website for updates and what will be proposed on the 19th. And then we'll know a little bit more about that one. So I don't see any questions right now. I will go to the next slide.
Okay, so as promised, AB 685. So this was just passed through legislation and signed by the governor. It will become effective January 1st, 2021. And remain effective for 2 years, so basically to January of 2023. And I think we're all hoping that it won't be necessary beyond that. And maybe we'll get lucky and it won't be necessary somewhere before that. But just know that this is technically in place unless repealed for 2 years. It amends the labor code at 6325. So there's an existing code there, and it's just inserting into it, and then will eventually hopefully be removed. A lot of it comes down to notifications. So when an employer receives notice of potential COVID exposure within 1 business day, so note that this is where in your COVID plan or whatever it is that the division comes up with eventually, your management really needs to be trained on all of this and have a very quick response and turnaround time in place. So I'll step back, when an employer receives notice of potential COVID exposure, then 1 business day, you need to have written notification to employees, as well as if you have other contractors on site, that those contractors, the employers, not their employees, but those employers, anyone who's on site and is possibly exposed to a qualifying individual. So qualifying individual is defined in the new section of the Labor Code as any person who has a lab confirmed case or a positive diagnosis from a health professional or healthcare provider, or an order from a health department to isolate, or lastly has passed away of COVID-related illness. So that would be considered a qualifying individual. So this applies to anyone who's had a potential exposure to that individual. You also have to provide written notice to any union representatives that may be representing your employees. And then you have to provide those employees and their representatives with information on benefits. And this runs the gamut, so I definitely suggest reading the new code. But it does include federal benefits, state benefits, local benefits, workers' compensation, as well as options for sick leave. So I highly recommend taking a look at that and figuring out exactly what it is you need to be providing them with. You also need to notify everybody of your response. So basically your disinfection and your safety plan for how you're going to disinfect and then prevent. So again, this kind of goes back to having that COVID plan in place. And if you have one of those, at least you have a go-to procedure, but you need to be informing employees. And so often this can be done by posting. If you have job site postings, that would be an appropriate place to inform everybody, at least that is on your work site. Obviously, if you have somebody out sick or away from work, you would need to notify them differently. If there is an outbreak is defined, again, in the new code as at least 3 probable or confirmed COVID cases within a 14-day period. That's for employees that aren't in the same household or real close contacts. So again, this probably requires a bit of sleuthing on your part because you may or may not know if someone is a roommate or lives with somebody or is a close contact. So that's something that you will need to look into. I would note that the outbreak definition says 3 probable COVID cases. So again, this is not necessarily it's not specifically saying absolute, diagnosed, or confirmed. It's probable or confirmed. So this is where you really probably need to err on the side of caution. And, you know, if it's something that seems probable, then assume that it is. So once you have what is considered an outbreak, and this, by the way, is defined on the State Department of Health's website. I would keep your eye on that because it's not technically defined in the regulation. Who knows if that maybe changes at some point, so keep your eye on what that definition is or becomes. When you have an outbreak within 48 hours, you have to notify your local health agency. And again, this comes down to, remember I mentioned before, the log 300 and the information that you have on your log 300. A lot of the information you're going to need to provide to the local health agency is that same information. So in a way, you're going to be putting it on 2 separate forms or providing it in 2 separate ways, but a lot of that information is consistent. It might be wise as part of your COVID plan to have a list of that information that you're going to need to provide. So whoever your supervisor or manager is doing this reporting has a hit list of what it is that they need to be given. You also need to do continued notification of your local health department of lab confirmed cases. So again, you know, the outbreak was probable cases, but maybe not confirmed. You need to follow up with the local health department if you do confirm those cases or if more come along. So again, it requires an awful lot of sleuthing on an employer's part where you may not be sure if somebody even has COVID or if they've got the flu. I mean, we're coming into flu season. And so I suspect it's going to be very challenging for employers to be identifying this. And again, as we're having a good solid plan in place makes sense, And then also probably erring on the side of caution so you don't end up with, the health department coming down on you or OSHA coming down on you as far as not complying. Lisa, do you mind going to the next slide?
I think, there we go.
So then just last little bit on 685 here. There's a few things that it changes. So the division has always had the ability to issue an order prohibiting use. For short, we call that an OPU. That's basically, if you have an unsafe condition, often it's an unguarded piece of equipment or something that's been damaged or faulty wiring, something along those lines. The division can issue an OPU and stop work on that work site or that particular piece of equipment until they have decided that it's safe to continue forward. What 685 allows the division to do is issue an OPU in a COVID-related situation. Now, it's limited to the immediate area where an imminent hazard exists. So if the division identifies a situation where they, for instance, think that there's not enough social distancing or there isn't proper sanitation, whatever it is that they're looking at that they feel there's an imminent hazard related to COVID, they can put an OPU on that particular area. Doesn't mean you can't have people working in other areas, but that particular area will have an OPU until the division has decided that it is abated. The other thing that's important to note is that 685 eliminates the division's requirement to issue what we call a 1BY, and that's because it's a form that's literally form 1BY, but it's the division's notice of intent to issue a serious citation. They're required to provide you with notification when they plan to issue a serious citation, and then give you 15 days to respond to that notice before they issue their citations. 685 eliminates their requirement to provide you with that notice. So you won't have notification that you may be getting a serious COVID citation, but as Lisa noticed, they're all going to be serious anyway. So it probably won't come as a surprise. And I think in a way, I know maybe this initially felt alarming to people, but it follows along with what we're often recommending, which is don't respond to 1BYs just generally across the board. That's typically your best bet anyway. So in this respect, I think actually it's probably better for employers to not feel the need to respond to the 1BY. So just know you're not going to be notified if you're getting a serious COVID citation. But honestly, if the division shows up and there's any kind of potential COVID violation, you're going to end up with a serious citation anyway. And then just anecdotally, I would add that we've been given information that the appeals board seems to be expediting COVID cases, even where abatement has been accepted. So if any of you have had the pleasure of going through an appeal, you would know that if you have a serious citation that has not been considered abated or fixed or corrected, the appeals board will put you in their expedited proceedings calendar. It condenses the normal appeal time to less than 6 months. So it's a very quick process. But if you've abated serious citations, then that's not the case. You're just in a regular appeal process that can take a year or more. And what we're hearing anecdotally is that the board seems to be really moving these COVID cases along, even where the serious citations are considered abated. So just be aware that your case will likely move a lot faster through that appeal process, for better or worse, than it would normally if those were non-COVID related citations. I see a question. Are they extending the extended sick hours? They were going to expire on December 31st. That is a really good question that I unfortunately don't have an answer to. I know that I've looked at the California, the governor's website, trying to look through his executive orders, and it's not the most clear. It's difficult sometimes to find that information. Your comp carrier may be a good resource for that. And Lisa, if you have any suggestions, certainly feel free to chime in.
I would agree, and I also know, AgSafe has some good employment lawyers that they work with. So there's this question as well as the question ahead of that. I want to address it, but I also encourage contact with somebody more, covering that issue with employment or HR. I don't know the answer to that. The previous question is regarding HIPAA. We're talking about all these notifications. In both the new legislation as well as the proposed regulation, we're doing a lot of notifying agencies and other people about illnesses or exposures in the workplace. And absolutely, there is some concern about employee privacy. Hearings, again, this is an employment lawyer, issue, I think more than ours. But what I have heard from them as well, I do think there's probably some privacy issues. I'm not sure if that's necessarily a HIPAA issue. When we do have a potential hazard, and without identification of the person specifically to coworkers, I understand if the comment is, well, the only person that's not coming to work, everyone's probably going to know who that is. But we still need to comply with the current, when we get to this current legislation as well as the regulation. So we can reach out, Lisa and I, as well to an employment attorney, because the question is probably best directed to them. But what I have heard from them so far is when we're dealing with a hazard in the workplace, that situation is going to trump or take precedent over a HIPAA concern. So we can get back to that. One other question I wanted to hear addressed on the 1BY, and I will do this generally. So the situation is we have a OSHA inspector very strongly stressing to the employer that they should respond to this. This does not change our answer. I will tell you why. That inspector may be doing this in good faith, may believe that the employer, should be having a dialogue about this. Don't dispute that for a second. But we have to look at what's the proper venue to have that conversation. And what I'm hearing from various people inside the organization is, one, that an inspector may have been told they have to issue a citation, they have to issue the 1BY. That does not mean that inspector has authority to walk that back or to change the classification. And if the decision to issue that as a serious came from a couple levels above, or above even the district office, responding to the 1BY is not going to change your situation. And as Lisa and I have both seen, at times that response can make the situation worse. So I think we do stick with our typical recommendation is that we're not going to do that. We don't feel, certainly we have no information to suggest that would be of benefit to the employer in this situation, in the COVID situation. And we absolutely recommend an appeal and a conversation about the legitimacy of the violation, of the alleged violation or citation, in the context of either an informal conference or just as your appeal proceeds. So not responding to the 1BY, there is no penalty for not responding. And given our experience, and I don't have any reason to believe that's changed with COVID, that you're going to have a more fruitful and maybe protected conversation later on in the appeals process. One thing with the 1BY is that it's a verified response. So anything that is included in that response is going to be used against the employer at hearing, wherein the appeals board has put in actually some additional mechanisms to have not privileged, but confidential settlement talks that would not be used in hearing as your appeal goes. So it's a safer way to do it. All is not lost if we don't respond to this 1BY, and no reason to change course on that. So I hope that answers your question as well. Thank you for that. We have time for, well, it's 2 o'clock. So I guess we went right up into the time. If anyone does have additional questions for us, you may jump onto the chat right now, or I will advance to this next slide, and our contact information is included here. You can reach out to either one of us if you have any maybe more specific questions or questions that we did not address during this presentation. Natalie, thank you for asking regarding the PowerPoint. We will get that to you as well. So if anyone wants to refer to that, again, with our little disclaimer that there's a new advisory meeting, you know, on schedule on Thursday. So things might be different then, but as of right now, this is how we understand it. So I appreciate the questions that we did have and your attention today. And thank you, Natalie and AgSafe for putting this on, and also for the resources that are included in your website. I found them very helpful. So thank you.
Yes, thank you so much, both of you, for your time and energy. So valuable as we navigate everything on this day-to-day basis. So we will be sure to send a copy of the slides as well as a link to the recording that you can refer back to. But again, as we stated before, be mindful that things are changing rapidly, and AgSafe, along with the Prince Firm, are trying to and navigate those and keep you apprised. So check back with AgSafe for updates. And then, of course, they graciously offered their email. So if you have any more questions, that they would be hopefully able to help you navigate a few of those. So without anything else today, again, we thank you so much for your time, and we hope everyone has a wonderful and safe day.
Thank you.